So this evening, we have the pleasure of having two wonderful attorneys sit up on this stage and engage in a very informal conversation with each other and with you. So with that, Will Trackman, our general counsel at Mountain States Legal Foundation, is going to be our moderator for this evening. And Professor Eugene Volokh is going to be our special guest. And they are going to take the stage, and Will is going to do introductions. Please, sir.
How's that? Good? Great. Well, I'm very happy to see all of you here tonight. I'm Will Trackman. I'm the General Counsel of Mountain States Legal Foundation. And with me is Eugene Volokh, a professor at UCLA. You can actually see Professor Volokh's official bio in your program tonight. But I wanted to give a different introduction because Professor Volokh has been helping to running the Volokh Conspiracy blog. I think at this point he's the last blog since I was in law school. So I graduated in 2005. I actually just went and Googled this, but at some point you had a trivia contest on your blog in 2004 asking which justices voted together the most often. And I got the right answer. It was Justice Ginsburg and Justice Souter, and you put the winners. It wasn't just me, it was probably like 10 people. And you wrote the full names of the winners. And so we are forever entwined in history on the Volokh Conspiracy blog. So if you want to read the official bio, you're more than welcome to, but the real hardcore introduction of Professor Volokh is he has run an incredible and influential blog. He is a professor at UCLA. He is one of the foremost experts on free speech and a true Renaissance man, because he's not just an expert on speech, but also on religious freedom, on the Second Amendment, on any number of topics. In fact, he has no idea what I'm going to ask him about, and he has nothing but confidence.
So, but let me just show you just how much we've defined Renaissance man now, right? So Renaissance man, it could be like Blaise Pascal, right? Founder of probability theory, student of physics and atmospheric pressure, theologian, and today a Renaissance man is someone who can talk about 2 of the amendments to the U.S. Constitution.
I said, the First Amendment has at least 5 parts, right?
Fair enough.
Okay.
Fair enough.
Well, this is meant to be a casual conversation. Let me start you off with a softball. What's it like living in California these days?
In many ways it's lovely, right? Look at the weather, and this is cold by our standards. It's beautiful. Los Angeles is one of the great cities of the world. People talk a lot about diversity, and I think overstated, misdefine it. The advantage of diversity to me is I like to eat it. But this is really one of the great things about Los Angeles is it has culture from all over the world, food from all over the world. My kids were at UCLA daycare, and they had friends whose parents were German, whose parents were Persian, whose parents were Chinese. It's a big world out there, and it's easy for kids who grow up in LA to see that it's a big world. So there's a lot to be said for it. Politics is awful, but fortunately, politics is only a part of life. I was telling my wife, who is I think you might describe her sort of as a moderate Democrat. That's the way she's always voted. And she's not terribly political. She's not interested in political things the way that I do, but it's certainly the way she'd always voted. And she's gotten completely alienated from the left as a result of California politics. So it has that going for it. So it's very bad in many ways, but in other ways, it's just lovely.
Well, that's good. I guess that's good to hear that you can make do. A lot of us, especially when we're in the trenches on the litigation battle, think that we're in a moment of constitutional crisis. Given the Biden administration and a number of the state-level efforts to confine liberties. On a scale of 1 to 10, where would you say we are on a...
So first I want to to make a pitch for my own little hobby horse is that everything should be done on a scale of 0 to 10.
Oh, okay.
Because we intuitively think that 5 is dead middle, and in 1 to 10, actually 5 is closer to 1 than to 10. It's 5.5 median. So computer people will also often talk to you, as I was. This is my first career as a computer programmer. Things should start with 0.
Okay, on a scale of 9 to 10.
9 to 10.
Where are we?
That's getting even more complicated. In terms of constitutional crisis, it all depends on compared to what, right? We do have a generally functioning constitutional system. First Amendment rights, for example, which I think are very much in jeopardy, still when it comes to court are pretty routinely vindicated. We have, while there's a lot of tension among the branches, we don't actually have pitched battles. We had an unpleasant experience a year ago, but it was a bunch of rioters who somebody pointed out, for the most heavily armed demographic in the entire United States, they sure didn't bring a lot of weapons, which is good. So what we had is a situation which was, I think, without any doubt, a failure of our political system, and a failure coming from the right. This is not the way a democracy should operate. Still is a relatively minor failure. And some of the failures coming from the left also. You look at the world at large, throughout space and time, 99% of all people would very much envy us our political system. I'm not even counting our economic system, just our political system. This having been said, I do think we have a lot of problems. We have some problems on the right. We have some from the left. I think probably unbalanced more from the left, but I think plenty from both. Some of them are things that can be repaired by lawyers, maybe. Some of the things you can maybe litigate your way out of. I'd certainly try. You folks do. It's great that we're here. Some of them, unfortunately, are not. I mean, I do think we are in a situation of political polarization, which on the one hand is perfectly understandable because people believe in things, and understandably they want to be represented by people who will stand fast in favor of those things. At the same time, you can't really run a country that's split 50-50, which as best we can tell it is. You can't run a country that's split 50-50 at the federal level with as much acrimony and as much lack of cooperation as there is. And I don't know what the solution to that is, but I do think it's a problem. So no, I mean, I don't think we have a constitutional crisis. I love to read about ancient Rome. They had constitutional crises back then. The last century of the Republic was all constitutional crises, one after another. Somebody once said France, the French love republics so much they've had 5 of them. So there's certainly plenty of constitutional crises in history, including recent history. Ours is not at that level, but it's not good. It's worse probably now than any time that I remember. Basically, we came to America in 1975. I started really following politics in the late 70s, probably starting around 1980. For all the faults, the Clinton years, and even the Obama years in some measure, were, I think, a lot better than what we've been seeing for the last 5-some years. And it's unfortunate, and I don't know what the way out of it is. I mean, maybe the answer is just come in the next election, maybe things will, the drunkard's walk, as mathematicians tell us, will turn us back to the right place. I don't know.
So we will be taking questions at the end. So if you think of a question, make a mental note or a literal note of it so that you can go ahead and raise your hand at the end. But I do want to ask you about a recent event that I saw in the last week. So there's a podcaster named Joe Rogan who has something like $100 million deal with the podcasting app called Spotify, and he had at least 2 guests there that were expressing skepticism about some of the COVID-19 common information. And then in response, Neil Young, who had a bunch of hits, I think 60 or 70 years ago, decided, well, I'm not going to have my music on Spotify if Joe Rogan's going to have his podcast. And then other rockers from that era also said the same thing, and ultimately it became this battle. Now, a lot of conservatives have said that's a bad indicator about free speech. Tell me what your thoughts are as a free speech expert. Obviously, your constitutional expertise may be at play here, but what's going on? What should we think about that?
Yeah. You know, it is bad. It's not awful. I mean, it's not like horrifically bad, because the fact is, throughout the history of America and in most democratic places, you know, there have been pressure put on various private institutions to try to block various things, to have whatever was sort of seen as the bad speech of the day. You know, sometimes probably for the good. But in any case, it's not like it's unprecedented that somebody would try to pressure a private entity to make it harder to distribute certain things they think is bad. But it's not good. And I think it's important also to distinguish two different things which we often call by the same name. Two different things we often call by the same name, and those are the freedom of speech and the First Amendment. So the First Amendment, as we know, famously applies only to the government. The first word of the First Amendment is Congress. Congress shall make no law. So the 14th Amendment is applied to states. No state shall, and local governments are basically subdivisions of states. And a common mistake many lay people and young law students make is they say, oh, this private employer is firing an employee for the employee's speech. That's a First Amendment violation. And we tell them, no. The state action doctrine tells us that it can't be a First Amendment violation if it's a private entity. And that's true so far as it goes. But then people learn that, and then somebody says, well, somebody is violating free speech. They say, no, you can't violate free speech unless you're the government. And that's not quite right either, right? Freedom of speech is potentially a broader concept. Sometimes it's a broader concept that's legally enforced. And by the way, you can agree or disagree whether it should be legally enforced. For example, in my own California, there is a law that bans private employers from firing employees. I oversimplify here, but basically this is so, based on their political activity. And the court has interpreted political activity quite broadly to refer to essentially the advocacy of a candidate or a cause. So any kind of political advocacy, even not of a candidate or a ballot measure, is protected. Now, maybe you might say that's bad. That's yet another way in which the government interferes with private employer-employee relationship. Maybe there are definitely costs to it. But it is indeed a protection of free speech, because if you worry about the chilling effect on public debate, that people are going to be as chilled by the threat of being fired as by the threat of being prosecuted, and sometimes more if the persecution is extremely unlikely and the firing is much more likely. In Colorado, there is no specific, I think there is a specific provision in Colorado, little enforced. But there's another provision in Colorado which bars employers from firing employees for any lawful off-duty activity. And speech is a lawful off-duty activity. I mean, if you do it off-duty. And there are cases in Colorado, in fact, where courts say, yeah, you can't fire an employee for their speech if you're a private entity, not because it's a First Amendment violation, because it's a statutory violation. And about half the states have versions of this. And then there's a third category, which is freedom of speech that's not enforceable by law. There's no law that protects it, and there probably can't be a law that protects it. But it has to do with certain habits of tolerance and the sense that, there may be speech that I dislike and may even think is dangerous, but we shouldn't be trying to boycott. We shouldn't be trying to block it even if it's not a matter of banning it. Because on balance, it's better if we have more of that rather than less. So I'll give you an example. Private university, right? California actually has a statute that bars private universities from expelling students or otherwise disciplining students based on their constitutionally protected speech. Again, an interesting question if it's a good idea or not. Probably, I think, on balance, a good idea. But in any case, there it's only California. It's not like with employment or other states like that. But one problem with speech, my sense of it now, I teach at public universities, there's a similar problem, but I think at private universities it's pretty much the same, is that students won't speak up not because they're afraid of being expelled, they're afraid of being socially ostracized, they're afraid of being mocked by their classmates, they're afraid that they might not get a job at some point in the future. Look, you can't really do anything about that, right? I mean, in fact, among other things, you have a constitutional right to ostracize people. I wouldn't want there to be a state law or even a school policy saying you can't ostracize classmates for your views. This having been said, I also wouldn't want a climate in the school where people felt like they couldn't express themselves on various topics, because that's bad for lively discussion in the school. So it's a long way of saying, of course, I'm a professor, so that's what we do.
What other way is there of saying
Exactly.
things? Yeah.
It's a long. At least I don't give you any footnotes. It's a long way of saying that part of the problem with the Spotify situation is we've come up with this sort of culture where the default seems to be try to organize the boycott. The default seems to be to deplatform, to try to block these intermediaries from distributing things. It's not new, in part because it used to be that you could only get stuff distributed if there were intermediaries. The intermediaries were things like newspaper publishers or book publishers, which actually had to be relatively selective, right? If you're a book publisher, you can't just say, oh, we'll publish every book, unless you're a vanity press. If you're a newspaper, you can't publish everything. But with Spotify and with Amazon and with others, with Facebook and with Twitter, we for the first time had a situation where technologically it was possible for them to publish things, and then people started trying to pressure them to depublish things. That, I think, is bad for free speech, even though it's not bad for the First Amendment as such, not a violation of it, but it is, I think, bad for free speech as a social institution.
Apparently there's a twist now, though, because the White House, through some channel, has urged Spotify to do more to stop Joe Rogan's podcast from putting on these COVID-19 guests. Okay.
So I actually looked into that, because some people have said, well, surely when the government encourages people to restrict speech, that is its state action. It certainly is government action, and the government is trying to do that, but maybe makes the entities themselves co-conspirators with the government and such. So it turns out, if you look at the cases, and they're almost all lower court cases, that's not what the courts say. What the courts say is if the government coerces private entities, says, look, we'll prosecute you if you allow this speech, or we'll deny you government contracts if you allow this speech, that is a First Amendment violation. There's a case on that. But I promise no footnotes. On the other hand, if the government is merely urging people to restrict speech, that's not a First Amendment violation. Let's take something way outside of the current debates. Imagine the New York Times is about to publish some story that's about CIA, what CIA is doing. And the director of the CIA says, this is going to be awful for American foreign policy. In fact, it may get some of our spies or some of our employees, some of our kind of people who are helping us in some country, might get them killed. So he calls up the New York Times and says, look, I can't tell you what to do. Of course, if I did order you to do this, you'd be in court first thing, and fine, I don't want to do that, but I just want to appeal to you as kind of good, decent people and good Americans. Can you not run this story, or perhaps more likely wait on running the story, or maybe run the story but don't mention these names or don't mention these details? And some of the times the New York Times will say, sure. I'm not sure that should be seen as a First Amendment violation. In fact, I suspect it shouldn't be. So here's the twist. Here's what makes it actually even more complicated, if it isn't already. So let's say, so you're asking about what's the problem with California. Well, being a landlord in California kind of sucks, as we've recently learned. But as a landlord, you still do have some rights, limited rights, and understandably limited, but some rights to go into the place you've rented out for inspections and the various other things. So let's say the police call me up and say, well, look, we're not ordering you to do anything, but there's a tenant of yours who we think is distributing drugs. And we just think if you're a good law-abiding person, maybe next time you go, or maybe you'll even find some excuse to go and kind of like check out the utilities, or check out the kitchen equipment. In the process, why don't you nose around? Interestingly, that makes my search a government search, because it was urged by the government, not compelled, urged by the government. So the Fourth Amendment, not every case, but a lot of cases say that merely asking people to do something when the government does it may in fact violate the Fourth Amendment. And the First Amendment, no. Is that right? I don't know. So there's a viable theory out there potentially, but on balance, I'm not sure it's going
It
places.
seems like some tension between the first.
There is. That's why I bring it up. You guys should litigate it.
Okay, with you as co-counsel, right?
This one I'm going to sit out as an academic.
Got it. Well, let me talk about a different form of speech because you mentioned Mountain State's Legal Foundation, our litigation. We filed an amicus brief a few months ago in a case called 303 Creative versus Alanus. This is a case out of Colorado where a website designer is actually going on offense against the state of Colorado and suing, saying that a Colorado Civil Rights Division doesn't have the right to crack down on its website design business under the state law, which says you have to serve same-sex couples equally, because this website designer doesn't believe that they ought to have to develop, create content, and post photos of a same-sex wedding based on their religious beliefs. We didn't tackle the religious angle, but we thought that this is a speech issue. And what's interesting is that the 10th Circuit, the appellate court based out of Denver, they said, yeah, it is a speech issue, and so we're going to apply the form of strict scrutiny. We're going to look at it really closely, and it meets strict scrutiny. Right. Which I thought that's the first case I can think of that said, okay, yeah, strict scrutiny applies. It meets that. Yeah, so let me explain it. So strict scrutiny, generally, court is going to look very closely at a law and say, is there a compelling need for this law, a compelling state interest, and is there a narrow tailoring? That is it a close connection between what that interest is and what the law does? Here, the court said there is a compelling interest in protecting same-sex couples from discrimination, and there was a narrow tailoring. The anti-discrimination law, was necessary in order to achieve that interest, so it would succeed. Professor, what do you think about that?
Well, so let me start with something very different.
Go ahead.
I promise I'll bring the. So if you guys do a search on Twitter, not that I advise you to, probably not a good thing to do. If you search the right keywords to find Mountain State's Legal Foundation and Volokh, you're going to find this guy Charles Nichols, who's a advocate of open carry of guns. And he and I have had some run-ins, and peaceful, but let's just say we differ on various subjects. And he's tried to make this thing, or like try to get viral this thing about how Mountain State's Legal Foundation is inviting this left-wing law professor, Volokh, to come and talk to. Why would they do such a thing for this notorious liberal? Which is just a sign, everybody's left-wing compared to somebody. But the fact is, I think he thinks I'm soft on open carry, which I am. I actually support the right to bear arms, including the right to carry guns. I do think the government's entitled to say you can carry concealed but not open, or you can carry open but not concealed. In any case, it's an interesting question, but I do sometimes end up reaching positions which are kind of, not sure centrist, because that suggests kind of a consistency to them. Let's just say neither fish nor fowl, somewhere in some weird place where people say, Volokh, why would you think those two things together? So my general rule is photographers yes, bakers no when it comes to these things. And I'd put the web designers there too. So I actually filed a bunch of amicus briefs in these cases, starting out in a case in New Mexico, where New Mexico Supreme Court, despite our best efforts, ended up in the wrong direction, involving photographers, wedding photographers who refused to photograph same-sex weddings. So in my view, there was that given that the First Amendment has recognized a right not to speak, which includes a right not even to display speech. There's a famous precedent called Woolley v. Maynard, which involved a law that requires basically everybody to have on their cars a license plate, and without the motto of the state, in that case it was New Hampshire, the motto was live free or die, requires them to display it and not cover it up. And the Maynards, who were Jehovah's Witnesses, they opposed the display of this motto. They covered it up. They got threatened with jail time for it, which is a funny thing for live free or die. But eventually that came to the U.S. Supreme Court. The Supreme Court said you can't be required to even display speech on your property, even in a context where everybody understood it wasn't the Maynard's view, right? You're driving down the street, you see the standard state license plate. You don't think that it's there because the drivers endorsed that message. It's there because the state endorses the message. But the court says, no, you have a right not to display things on your property. It seems to me, display speech, excuse me, not things, that's actually important. Not to display speech on your property. It seems to me it extends to the right not to create speech. So I think if a photographer says, I do not want to photograph same-sex weddings, or, I'll give you an example, I'm not religious, but I'm ethnically Jewish. My wife is not ethnically Jewish. To Jews, that is, we wouldn't quite say interfaith, that's not exactly the right term, but that is a mixed marriage, and I imagine there may be some photographers who say, we don't approve of that, we don't want to photograph that. That would be technically discrimination based on religion or maybe ethnicity/national origin. I'd say fine, if you don't feel comfortable photographing our wedding, I don't want you photographing our wedding. I want somebody who's really all into it. So photographers, I think, should have a right not to photograph things, including for bases that are discriminatory. Another example I give, imagine a wedding singer. Seems to me if you're going to be singing, even for money, you're entitled to say, I just don't want to sing at this event. And other analogies that I offer, these same laws that ban discrimination based on sexual orientation also ban discrimination based on religion. Well, what if somebody says, I don't want to write press releases for the Church of Scientology, or for the Catholic Church for that matter, or any religious group, because I just don't want to actually write things that endorse a view that I disapprove of. I think they should be free to do that. Bakers, no, because there's no right to cakes in the Constitution. I mean, to be fair, there's no right to websites either, but, speech and press pretty closely linked to web design, pretty closely linked, I think, to photography, videography. And actually, by the way, I think that if the cake baker, says, I don't want to write this on the cake, they should be free to do that. But if it's just a matter of baking a cake or driving a limo or renting out a hotel, I think that it may be that you should still be free to make that choice, but I don't think there's a First Amendment right there. For 303, though, I'm totally on your side.
Is that because there's something mechanical that's too easy to make a cake?
No. Oh. The example that I give is, imagine that somebody were to say, you can't have more than 2 bakeries in our little town because we basically just like the 2 incumbent bakers and we don't want competition. Very bad law. Really bad for economic liberty, really bad in all sorts of ways. Not a First Amendment violation, right? Why? Because baking a cake is not covered by the First Amendment. On the other hand, I do think that if the city wanted to say we can only have 2 newspapers in town, clear First Amendment violation. And if they were to say we only allow 2 photographers in town, I think that's also a First Amendment violation because the First Amendment protects photography, protects newspapers, doesn't protect cake baking. So I think whenever you have a freedom of speech and freedom of the press, you gotta draw lines about what counts as speech and press. And it's true there's some things that might end up doing that, and I actually wrote an article, and there's actually a lot of history about symbolic expression, waving flags, burning flags. I'm all board with that. But it's still gotta be a relatively narrow zone. And I think baking cakes is outside it. So just as I don't think a restriction on baking cakes, however bad the restriction might be, is a First Amendment violation. I don't think a mandate of baking cakes is. On the other hand, a mandate or a restriction on web design, I think is a First Amendment violation.
Well, I'll take your concession that you're a notorious liberal squish on
yes,
this
exactly.
issue. But I'll leave it there rather than continue disagreeing. Let me ask you about a different speech issue. This is coming up in a lot of schools where a student is saying, I don't want you to use the pronouns associated with my biological sex.
Right.
So I was, my birth certificate says I'm a boy or a girl, but I now identify as either non-binary and I'm a they or Z or whatever. And so the professor, or the teacher in the school has either a religious belief or just a conscience belief that sex is immutable and I'm going to keep calling you Mr. This or this. And so because that's in the government school.
Right.
So what does speech and what does the First Amendment have to say for that teacher?
Well, so I think it's complicated because there are because I think it's complicated because there's an important free speech right here, which I think a lot of people miss. But there's also an important, not even government interest, but important government function here, which I think we shouldn't miss either. So the reason, as I understand it, why many people feel so strongly about this is that they think that using a particular pronoun conveys a particular statement about the world as it is. And they just don't want to say something that they think is false. There's a famous essay by Alexander Solzhenitsyn, which is actually the last thing he wrote in Russia before he was expelled. And it's called Live Not by the Lie. And his point was that everybody needs to resolve never to say anything that they believe is false. And he, while a moral absolutist in many ways, he was certainly very alive to the fact that different people have different views about it. He was totally on board with it. He said, yeah, I'm not saying you should always only say things that I think are true. You should only say things that you think are true. You should never say things that you think are false. And that's, by the way, one reason I support the wedding photographers, because they feel that their photographs convey the message that this is a wonderful, holy even event, and they can't do that about weddings that they think are unholy in a sense. Maybe I wouldn't use quite that term. So likewise, I think for some people they say, I use a pronoun to refer to somebody. It's not a big deal. It's just a reflection of what they prefer. Just like I use their names because that's what they prefer, but because that's just there has no logical significance that somebody calls me Eugene. It just happens to be the label that I've gotten used to. And that others know me as. But no, for many people, understandably, pronoun is a judgment about what this person's true sex is, and they feel it's wrong to say the contrary. On the other hand, government school teachers are hired to do a job. And the government as employer, I think, has to have a considerable amount of latitude over what government employees say as part of the job. I'm actually quite troubled when people get fired for what they say off the job. But if somebody is teaching kids and the school concludes, rightly or wrongly, that the kids will learn better from this person if they know this person is using, say, the pronouns they prefer, that's a pretty significant argument in the government's favor. Probably on balance, I would come out on the First Amendment question there. Universities may be different, or maybe they shouldn't be, but it's complicated. It's even more complicated. But I think in the school context, again, it's government employment. One way of thinking about it is we, I think, had something similar some decades ago, not the same by any means, for Ms. and Miss and Mrs. Right? So it used to be the rule was Miss for unmarried women, Mrs. for married women, and then somebody invented Ms. Which on balance is a great idea. For a variety of reasons, one of which is I don't actually want to have to keep track of the people I'm corresponding with. Are they married or not? And then you use the wrong one and they're kind of upset for whatever reasons. In fact, if somebody did come up with an M period, as some people are suggesting, I think it's just, I don't want to use it now because it's too new, but if it had been well established, it would have been wonderful. Let's say somebody, for example, insists that in correspondence to their clients and this government job, the correspondence to members of the public, he's only going to refer to women as Mrs. or Miss, even if they prefer to be referred to as Ms. I think the employer might say, look, we hired you to kind of improve our relationship with our clients and not worsen it. So we want to insist that when you're on the clock, when you are talking to people whom you're talking to for your job, you talk to them the way that we tell you to, which happens to be the way they think they prefer. So again, it's not totally on point by any means, not totally analogous. That's why it's an analogy, not an identity. But I do think that when somebody is employed to do a job, the employer, generally speaking, has a good deal of flexibility over how they are to do the job.
Well, let me shift gears, but first a reminder that we are going to open the floor for questions. So if you have a question in a second, good. I already see one hand. Hold on a second. I'm going to ask one more question, then we're going to open the floor.
Go for it.
So There's a lot of talk lately about regulating social media platforms like Twitter, like
Right.
Facebook, because I don't think this is actually very disputable. Those platforms discriminate against conservative viewpoints in at least some form,
Right.
either through throttling conservative content
Right.
or enhancing liberal content, or what do you call it, blocking conservative speakers, maybe President Trump. What are some of the issues in terms of regulating those platforms and forcing them to treat conservatives equally?
Right. So I wrote an 86-page law review article.
Can you just summarize that for us here? Yeah.
I have it right here in my pocket. I'll read it to you. Here's my general answer, and I guess there are three components to this answer. One component is we should always remember being conservative-ish, libertarian-ish, free market-ish. I mean, I say ish just because nobody is all one thing. Everybody understands that the world's a complicated place. But as a general matter, there are very few problems that cannot be made worse by government regulation. So it is certainly very easy to imagine that the government steps in, tries to do something that makes things worse. And that's totally something we should always keep in mind. And it's not like the problem is horrifically awful now. In a sense, speech is much freer in this sense that it was 20 years ago, right? Before most people couldn't speak at all. Now, 99% of people can speak, and then maybe 1% get banned. It's still an improvement. So it's not awful, but it could get awful, right? Especially in a country that's split 50-50, and with institutions, big tech institutions that seem to be developing an appetite for further restrictions, it could get worse. So I think it's a serious problem, but there's always the chance that the cure is worse than the disease. The second thing to keep in mind is that whatever viewpoint neutrality rules you're going to impose, they really have to be themselves viewpoint neutral. So I've heard some proposals, for example, saying, well, you can't discriminate against ideas unless they involve advocacy of self-harm or illegal conduct. Well, that's clearly unconstitutional, right? You can either say we're going to demand viewpoint neutrality of platforms, or you can say platforms are private entities, they can impose whatever rules they want. But you can't say, well, we're going to protect against viewpoint discrimination, except we're in the process going to discriminate by law against these viewpoints. So that means if the platforms can't censor conservative views or liberal views, they can't censor pro-terrorist views either. I mean, they can censor outright conspiracy to engage in terrorist acts, but merely somebody saying, yeah, I think ISIS has the right views and everybody should support ISIS, they wouldn't be able to censor that either. Maybe on balance, that's good, right? The post office can't censor ISIS mailings either, and I think it's better than the post office having the power to block whatever it wants. The phone company can't cancel your phone line because it thinks you're supporting self-harm or eating disorders or terrorists, and I think on balance that's a good rule. But that's one thing to keep in mind. And the third thing is when we say about social media platforms, we have to recognize they have many different functions. And let me just mention three. One is what I call the recommendation function. And there it seems to me it's just as protected by the First Amendment as the power of a newspaper to decide which stories it wants to cover, or the power of Citizens United to decide that it wants to use corporate funds in order to advocate against Hillary Clinton and not for Hillary Clinton. So if Facebook is saying, here are the things we recommend, either based on our own recommendations or based on our judgment of what you might like based on what you've watched before, it seems to me it has a First Amendment right to decide what it actually affirmatively promotes when people are just sort of see, here is my news feed. So that's one thing that's clearly First Amendment protected. The other polar extreme is what I call the hosting function, which is, again, just like the phone company carries a phone line, or just like UPS or FedEx, other examples of common carriers which aren't allowed to discriminate. Deliver packages or don't deliver. Well, they have to deliver unless somebody doesn't pay. Deliver packages from certain bookstores. So that's the function of providing access to people to speak and for other people to read those things they've actually chosen to read. There, I don't think there's a First Amendment problem, or at least an insuperable First Amendment problem. There's a First Amendment issue, but I don't think a First Amendment violation if the government says you can't discriminate based on viewpoint in what phone lines you carry, or what packages you deliver, or what Twitter feeds you host, or what Facebook pages you host. And there's the third thing, which is kind of in the middle, which is what I call the conversation management function. And that's comments and other things where people, where it clearly isn't Facebook or Twitter speech, but at the same time, it's something where you might end up running across things on the page you choose to visit that aren't posted by the page owner, but are posted by someone else. We have to have platforms have at least some latitude because of spam. Because otherwise it would really be unusable. Facebook and Twitter would be unusable if they couldn't block spam comments. Now, but maybe you could distinguish spam from other things, but you know, I do think they're providing a valuable service if they do block insulting or borderline threatening or other such comments, because it makes for a more pleasant conversation. It doesn't bother me at all that some bad person is on Twitter with his own feed. I'll tell you, for example, Twitter does not ban pornography. There are lots of Twitter feeds, porn Twitter feeds. But people don't stumble across them because they don't follow them, unless they do follow them, in which case they get what they're asked for, right? On the other hand, if there was lots of porn spam on Twitter or on Facebook, then in that case, or for that matter, lots of Nazi spam or KKK spam or various other things, you know, that would make those places, I think, a much less pleasant place for conversation. So where that plays out in the First Amendment analysis, that's actually, I think, a very difficult call. But I think it's important that if we are trying to regulate the platforms, if it makes sense, and maybe it does, you don't regulate away some of the real value that they add, even though you might want to regulate their hosting function to make sure they're more like the phone company or like UPS or FedEx with respect to that.
Interesting. All right, let's definitely open the floor. I see we have at least a few questions. If you do have a question as we talk, definitely feel free to get in line. But we're going to start with John Rockwell over here.
So I think it's interesting that you allow employers to kind of control speech. And I think you've got to make a clear distinction between government employees or employers and private employers. So if I hire a bunch of people and I say you can't talk about anti-Christian things, it's kind of my deal. But the government's a whole different thing. All they've got to do is add a lot of employees and tell them all they've got to be the Third Reich, and we're screwed. There are employees, and they're called service employees, and to allow the government to control their speech is entirely different than for me to control the speech of my employees.
Well, it is true that the government as employer is constrained by the First Amendment, whereas private employers are not, although they are constrained in many states by state laws. But when it comes to the government telling its employees what to say as part of their job, that is something that is, generally speaking, not terribly constrained by the First Amendment, and I think rightly so. I remember going to talk about, not the First Amendment, the Seventh Amendment, which is the right to jury trial in civil cases. Actually was about jury trials in civil cases. John Langbein, great scholar of civil procedure at Yale, was talking about how he thinks the jury system is a bad idea, especially in civil cases. Somebody gets up and asks, well, what if the Nazis come to power? We wouldn't have this check on government power. And he says, you know, whatever you might say about the Seventh Amendment, preventing the Nazis from coming to power is not going to be something it succeeds in doing. The First Amendment might help prevent the Nazis from coming to power, but not when it comes to government employment. Because any working government system has to be able to tell government employees, here's what you say as part of your job. I mean, if we hire military recruiters, I want the military recruiters to tell their the recruits, I don't want them to lie, but I want them to tell the recruits, yes, you should come join the military. And if some recruiter, as part of his job, says, you know, you realize war involves killing, and in the Bible it says, you shall not kill. So if you join the military, you'll be damned to hell. I think the government could say, you should find another line of work, right? Because we're hiring you to accomplish a task for us. Now, it's not Third Reich, it is promoting militarism. Lots of people may disapprove of that. I understand, and if you want to vote to ban the military recruiting, you could, but so long as we have military recruiting, we have to make sure the recruiters recruit. Likewise, if the military recruiter were to say, everybody should come to the military, but not Jews like you, or not blacks like you. They want you, but I don't want you. That's a permissible view for him to have. He's just not going to be a very good recruiter. So likewise in the teaching context, right? I think we can insist that teachers teach kids a particular curriculum. I think we can insist that they teach kids in a particular way. And I think we can insist that the teachers refer to the kids using particular pronouns as part of their job. I don't think you should be able to tell them, and we're going to fire you for that op-ed you wrote or that letter to the editor. But when you're on the job, it seems to me you have to do the job. And that means the government is entitled to tell you what your job is, including when your job involves speech.
John, do you want to follow up? Hold on. Let's wait for the microphone.
I want to say that doesn't hold water, particularly right now, where we've got government organizations telling us that you've got to pay particular attention to blacks and Latinos and whites, and that whites are bad. This is entirely anti-freedom, and the government should not be allowed to do that.
Well, okay. So we have public schools. Now, many libertarians disapprove of public schools, and there's a good argument that as a matter of sort of political theory first principles, you don't want the government to be involved in teaching. Maybe we should have the government fund schools, maybe we should have entirely school choice. A perfectly understandable argument. That's not been American history. And throughout American history, the government has run schools with an eye towards, among other things, teaching kids what is thought to be good citizenship, teaching kids to believe in certain things. And the classic example, of course, is the flag salute, right? In 1943, the Supreme Court said kids can't be required to salute the flag. Makes perfect sense. But kids can be encouraged to salute the flag. That's why we still have flag salutes, at least in many schools, not all schools. Maybe we should have more, maybe we should have less. But that's something that's left. The curriculum for the schools and the teaching, the ideology that's being taught in the schools is left to the political process. The schools don't have to teach that, communism is wonderful or fascism is wonderful, but they can teach that democracy and capitalism in America is wonderful. And I don't think they should teach that kind of in a way that's self-defeating, but I think on balance it's probably a good idea. But that means that when I lose, then somebody might be able to, if they run the school board, if there's enough votes, say, socialism is wonderful. That's the political process. Likewise, there are some states that are banning the teaching of certain things associated with critical race theory. It's vast oversimplification, but basically that in public schools. I think that's a big mistake at the college and university level for academic freedom reasons we're happy to get into later. But when it comes to the curriculum of K through 12 schools, it seems to me the legislature is entitled to say, look, we teach kids here, we want them to learn things that we think are good and not things that are bad. But that means that when a school teacher says, no, I insist on turning my history class or my math class into a critical race theory class, it seems to me that the government is entitled to say, no, we want you to teach these things this way, not your things your way. And if you agree with me on that, then I think we are in agreement that the First Amendment just doesn't really apply, at least in a big way, to government employees when they're when they're speaking as part of their job.
Let's go over here.
Thanks for coming tonight. First of all, Mr. Nichols, your
Yes.
Twitter troll you mentioned earlier, I tolerated him up to a point. I don't know if this isn't censorship because I'm not the government, but I eventually blocked him when he started morphing your face into Stalin. And
I didn't see that.
I thought that crossed the line.
I don't look good in a mustache.
Okay. Anyway, working in a university to outsiders seems hugely fraught now with peril if you're a professor. The years that you've been teaching, have you found yourself self-censoring? Have you found yourself walking on eggshells out of fear that any accusation can come flying out of nowhere, and then you end up at the butt end of sort of a mob reaction to what you're teaching or saying?
Well, yes and no. Let me explain why. So first of all, some amount of self-censorship is inevitable, and in fact, it is an excellent idea. Every so often, I get an email from somebody, not Charles Nichols, but somebody else like that, which is like, why? You're not writing about this subject. Why aren't you? I say, it's really complicated. No, I know why you're not writing about it. You're just afraid that all of your buddies are going, or all of your colleagues are going to pile on to you and condemn you. I say, no, you got part of that right. I am afraid. But what I'm afraid of is I'm afraid that I'm going to screw it up. I told you I don't know that much about the subject. You're trying to tell me I should write about something I don't know much about. I don't want to do that because I might look like a fool. That's a form of fear. That's a form of self-censorship, right? We limit our, at least if we're smart, I wish more people had this kind of self-censorship. We avoid saying certain things where we think we might be wrong in various ways. So some amount, and the similarity is because we're afraid of condemnation, right? Because we're afraid of being looked down on, but for good reason. So I think the key in life is to self-censor about those things you should self-censor about, and not those things you shouldn't. So I see, though, what you're getting at, and without question, there are certain things that I think are right, and that I'm afraid of speaking about, and I speak about them in any event, because I think it's kind of my duty. I have tenure. I got the tenure, which is a very unusual thing. You say it's hard in universities. Well, in most places, you don't have tenure, right? It's harder in universities probably than there should be, but it's a lot easier, a lot safer in universities than in many workplaces, probably in most workplaces. So I feel the only purpose of tenure really is to make sure that people do say things that are right, even when they are afraid of bad reaction, by limiting the level of reaction. So I do it, but there's no doubt that other people who don't have tenure, they're not tenured yet, or they're not tenure track because they're just lecturers and not professors. That's the title. The title lecturer is basically people who teach. And sometimes even do some research, but are not on the tenure track, or because they're looking to move up to a different school or whatever else. I think it's a very serious problem out there. I think it's hard to do that much about, in part because a lot of the fear isn't of things you can regulate, like firing, but things that you can't regulate, like, for example, someone not hiring you for a new job, where they just say, well, we just think you're not good enough, right? Very hard to do anything about that. Or people just kind of sneering at you, or thinking that you're a fool, or thinking you're evil, or whatever else. But I do think that this is a very serious problem, and it's to the point where I do think a lot of people aren't speaking out on questions such as transgender issues, such as affirmative action, such as abortion, such as a variety of other things. And I think that's very bad for, again, free speech, for academic freedom, not necessarily the constitutional doctrine. It's very bad for kind of a lively exchange of ideas that only comes from an environment where people say, you might be wrong about this, and we'll disagree with you, but we're not going to try to get you fired or blacklisted because you're wrong, because the problem with that is then people are going to not talk even about things where they may be right because they're afraid of this kind of reaction.
Nick?
Professor, I'm really intrigued by the observation you made about the Fourth Amendment case law that essentially extends state action doctrine to private action on the basis of encouragement, but that you have found, I've actually found a couple of cases where a similar result happened in the First Amendment in the 60s, dealing with anti-communist behavior. But put that aside. I find it fascinating that there is this line in the main of the cases between the Fourth Amendment and the First Amendment. And I find that to be I think it's a hard line to maintain, because the First Amendment is supposed to sweep broader. You have the chilling effect doctrine and so on, and you would think that the policy justification for applying that expanded state action doctrine in the Fourth Amendment would have even more power in the First Amendment. And you seem reluctant to extend it, and I'm curious as to your reasons, and let me just throw this context for you. I mean, in a pervasively regulated world where discretionary administrative decisions control our lives, where we're violating the law 10 times a day, as they say, a government official doesn't have to tell you in words that you must do what they tell you or else. They could be, there's this old joke in Chicago where you go to the mayor and you ask for, how much he needs to be bribed. He takes you over to a picture of a stadium, and he says, well, let's just talk about the stadium here. How many people do you think are there? And you say, well, 10,000? No, I think that's a little, maybe more like 50,000. So that's how government behaves when they have all the leverage that they need. They don't have to say things in words. So please, I want to hear your thoughts on why in the real world context where government is all pervasive, why shouldn't it expand? Why shouldn't that same doctrine apply?
Right. Well, I think there's a good argument that the two should be treated the same, the First and the Fourth Amendment, but then it's not clear which one, whether one should be expanded or the other should be contracted. So let's just look at the First Amendment thing. I totally appreciate the argument that the government, first of all, can subtly pressure people into things, pressuring by implicit threat of retaliation. Like with Twitter, it could be, well, like you're a large company, you're going to be subject to all sorts of regulations, maybe you have some antitrust thing pending before us, or there's always the risk of new statutes being enacted. If you don't see things our way, our party is going to regulate you more or something. Totally, it's a really serious concern, no question at all about it. At the same time, let me give you another example beyond the national security one. There is a hostage situation, somebody's home, and there's a TV station filming, and the policeman comes over and says, "Look, I can't tell you to stop filming. Of course you have a right to film, but if you air this, the guy in the home is going to see that we're preparing to storm in through the back window. He'll kill everybody. You think you could just kind of be a little bit more responsible here? Should that be a First Amendment violation?" Okay, you might say, well, that's just life and death. Well, or that's sort of immediate life and death. I mean, every so often we also hear about things like people saying, we don't think you should broadcast this footage of, let's say, somebody's dead body. You have a First Amendment right to do that, but it's disrespectful to the relatives. So imagine it's a government official, imagine it's the mayor who says this. Do we want the government to have a First Amendment obligation to never say anything like that? I don't think so. I mean, you can imagine saying, yes, as a prophylactic rule, the government should never be able to say that. Maybe. I certainly don't see any case law really supporting that, and I'm not sure that that's really the right rule.
Look, I respect that, but let me give you a perspective from G. Gordon Liddy. All right, he's a character. We all know this, but he knew what he did was wrong, and he said he was willing to do the time, right? And I think that we should have a similar approach to this. If the government violates the First Amendment, but you do the time. You pay the liability. You suffer the consequences. I think it's dangerous to say that because we want an outcome we deem as a good outcome, to deviate from a principle.
Well, that's not usually the way we treat constitutional rules. Generally speaking, when we say something is unconstitutional, we're saying the government ought not do it. I mean, after all, they took an oath. They took an oath not to pay for violations of the Constitution. They took an oath to uphold the Constitution. Now, it's true some of the time they're going to screw up, and at that point they should pay, and they understand that, and we understand that. But I don't think we want to have a constitutional regime that is extraordinarily demanding, and when it leads to results we don't like, we say, oh, no problem, you violate the Constitution, then you just pay damages. Again, I don't think that's consistent with the oath. I don't think it's ultimately conducive to the rule of law. So look, I'm not firm on this, but I would think a lot before I would back a rule that says the government may never encourage people not to say so.
Look, I think we're in agreement on that, but I just want to say, don't you think we need to have more research on this? Shouldn't there be a lot more?
Well, I certainly think people should give grants to law professors to write articles about this.
I think we do have time for another question. Yeah, David?
If I can be indulged, I have two. One is very quick. The first is, Professor, I would really like your assessment of how the Supreme Court's going to approach the racial discrimination case.
Oh, I don't know.
That's before it. And the other is, I think as diversity, equity, and inclusion has become endemic throughout society,
Right.
it masquerades the fact that it is an expression of the exact opposite, which is an insistent homogeneity on thought. And it was spawned in your profession, in academia,
Right.
and 60 years of it being ubiquitous there has given us the bitter harvest that we've reaped now in leadership positions in every walk of life in America. My question on that is, do you agree, and if so, what is the solution, and what, if any, role does litigation have in obtaining it?
Well, these are very hard questions to which, unsurprisingly, I don't have an answer. They're differently hard. The first one is hard just because it's hard to predict things, and my track record of predictions of the way the Supreme Court will decide cases is pretty weak. So look, they had the opportunity to reject race-based affirmative action, even with a conservative majority, and they didn't back in the Fisher case. Will they do it now? Will they do it only with regard to the particular programs that are involved at Harvard and UNC, where the particular challenge is discrimination against Asians, or will they say something more generally? It's possible. I mean, I don't like to overstate conservative liberal divides, but on the court they do tell us something. It looks like we've got 6 votes potentially on that side. But again, we had 5 votes before and it didn't seem to work. Maybe it wouldn't work this time either. I don't know. It's really hard to tell. As to the DEI problem, which of course is a whole bunch of things all rolled into one, I don't know the general answer. I do think there is a lot of role for litigation. I remember I got an email from somebody who teaches at a public university in California, who says, look, I support race-based affirmative action, but I know this Prop 209 is out there, and I know that you, Volokh, were involved in it. I helped draft corners of it back when I was a very young law professor in '96. So he says, well, but I see it completely violated all over, all the time. I say, well, like many laws, it's under-enforced. Right? And we can fault lawyers all we want, and there's much among us lawyers to be faulted. But you can't have enforcement of the law, at least in the American system, without lawyers and without lawyering. So I think to the extent you folks do this, whether in California or in other states, I know Washington, I want to say Nebraska, a few others as well, there are statutory or constitutional provisions that ban race-based affirmative action and other just race discrimination more broadly in public employment, education, and contracting. I think some well-placed lawsuits might help people. I was about to say keep people honest. No, that's too high an ambition. Make people a little more honest. Likewise, with regard to some private systems, there are ones where Title VII has been interpreted as allowing some race-based affirmative action, but I'm sure there are a lot of programs that go way beyond what Title VII has been read to allow. So I do think that this requires a lot of litigation. It's often difficult to find someone who's willing to be a client in that kind of situation, and it's a difficult case to fight and win because you have to really get the goods. But I do think there's a lot of room for effective litigation.
David is not a plant helping us promote our newest case.
And what's wrong with that?
On behalf of Joshua Young, a former Colorado Department of Corrections sergeant who we just brought a case 2 weeks ago, who was forced to do DEI training that said all whites are racist, including you. You're a part of white supremacy. If you disagree, that's part of your white fragility. And it told discussion group leaders that you should expect white norms and white talk as part of your DEI training sessions. And it has a big stamp of approval from the Colorado.
Right. So that's a somewhat separate thing, but there's room for litigation on that too. But I think for that there's also room for legislation. That ultimately, while of course all laws need to be enforced, they need to be laws first. And to the extent I'm not at all a supporter of laws that ban again, critical race theory and such in universities. I think legislatures should not be telling professors what to say. I think they may have the power to do that. I think it's not wise to have legislators exercise that. But I think in the context of classroom teaching in K through 12, and I think in the context of public schools, and in the context of public employment training sessions, I think the legislature is entitled to say that just as they wouldn't have sessions that say racist things about blacks, they shouldn't have sessions that say racist things about whites, and that ultimately it's counterproductive to just the efficiency of the workforce to have that kind of thing. So to the extent that there are also statutes that can be drafted along those lines, I think that's a very good idea if they're properly drafted, and to the extent there's some good litigation, it's always good to have.
Well, let me close by getting you on the record on a hard question here. If I were to get you some Mountain States Legal Foundation merchandise, would you wear it to a Heritage Foundation event like you're doing with?
Yes, of course, okay. Of course. I was faulted for wearing a Heritage necktie, but my response was, they gave me a necktie and you guys haven't.
Duly noted, duly noted. We have a small token of appreciation here.
It's too small to be a necktie.
All right. Thank you so much.
Thank you so much, Professor, for joining us this evening. We appreciate it.